Lowndes webinars, Managing the Pandemic in the Workplace. We appreciate you joining us today to learn more about vaccinations and the kinds of conversations that likely or may be going on in your workplace. I'm Rachel Gebaide, and joining me today are my colleagues Morey Raiskin and Abood Shebib. We make up Lowndes Employment Law Team, and we are here to help you with all of your employment needs. What we've done today is develop a hypothetical which takes into account a number of the issues that might come up with respect to vaccinations and the safety precautions that employers are implementing still during the pandemic to keep their facilities and their employees safe. So we had a hypothetical that has been emailed to you ahead of time. I think it went out in the last 30 to 45 minutes, but we will be sharing it on our screen today. If you have your own copy, you can follow along there as well. I'm going to turn it over now to Morey Raiskin, who will walk us through the hypothetical, and then we'll start the conversation about how the fictional workplace in the hypothetical can manage the different issues that arise. Morey?
Hi, and thank you for joining us this afternoon. We are very privileged that you're here and happy to talk with you about the issues we're going to present through this hypothetical. When you have questions, please type them in the Q&A function, and we will try to get to them and weave your questions into our presentation. I understand it's virtual, but we'll try to make it as interactive as possible. So the hypo, Alexa, a contractor working at the Orlando headquarters of an internationally famous clothing manufacturer, is responsible for temperature screening all employees and customers who enter the facility. She is paid by the number of screens she performs. One day, the number of people who arrive simultaneously swells significantly. Her equipment malfunctions. A lengthy backup results, which frustrates the hourly employees. The line surges forward. The employees at the front of the line bump into Alexa, who falls and breaks her wrist. Billy, Carlos, and Devante were unable to clock in for their shift for nearly 30 minutes. Their supervisor wants to discipline them for being late. Elena, Florence, and Grace refused to wait and simply left the line and reported to work without undergoing any temperature screening. The HR department wants to discipline them for failing to follow policy. Their supervisor maintains that because they showed their vaccination cards to her when they got to their workstation, they should not be disciplined. While the company was deciding what to do, Elena, Florence, and Grace circulated an email to all employees championing the idea that temperature checks and masks were both yesterday's news and no longer necessary in a post-vaccinated world, and asked others to join them in lobbying the company to drop this waste of time procedure. Billy, upon receiving the email, reported that Grace had told him she actually was not vaccinated, that she opposed all vaccinations and had forged her vaccination ID card just to make it look like she had been vaccinated. The company decided to poll all employees to ascertain who was and was not vaccinated, and asked everyone for a copy of their vaccination ID card or their plan to become vaccinated. Several employees refused to share this information with the company. Other employees refused to come back to the work site for fear they would be exposed to unvaccinated employees. Devante brought his dad with him to work on the day of the slow check-in so that his dad could shop in the company's on-site retail store using Devante's employee discount, which was allowed. Devante left work at lunch to drive his dad home. 1 week later, his dad was diagnosed with COVID-19 and now wants to sue the company, since he had not left home except when he joined his son at work, thus making it clear that he got sick at the company's facility. The company wants to defend the lawsuit and also fire Devante. You are the company's vice president of human resources and are called into a meeting, told these facts, and asked what the company should do. Abood? Let's start at the beginning. We'll start and break it down paragraph by paragraph. But what leaps out at you in that first paragraph about Alexa being a contractor, being paid to perform screens by the number she performs, and getting injured?
Sure. The issue here is going to be, I'm sure everyone's familiar, whether she is in fact a contractor or is she really an employee who's been misclassified. And that inquiry, there are several tests. There are tests under there's a general Florida test, there's a test for unemployment, and there's a test for workers' comp, and under Florida law. And here, she unfortunately broke her wrist. So you can anticipate that if you went to seek medical treatment, is she going to, and she claims, well, I was injured on the job. And the question is going to be, well, does she report that as a work injury to the physician, or where she seeks medical treatment? And if so, that physician, for example, may try to get payment on the treatment and find out, well, there's no workers' compensation here because she's actually a contractor. But the test under Florida law, for workers' compensation, there are two prongs really, and it's Florida statute 440.02, subsection 15, that sets out 6 factors that if you meet 4 of those 6, then you will be considered an independent contractor under Florida for purposes of workers' compensation. And and I'll go through those 6. First is you have to maintain a separate business with your own work facility, truck, equipment, materials, or similar accommodation. You have to hold or have applied for a federal employment identification number, the EIN that businesses have, unless you're a sole proprietor. And you have to receive, so that's the second one. The third is you have to receive compensation for services rendered or work performed, and that compensation has to be paid to a business rather than an individual. So a question here would come up is, how exactly is Alexa employed? Does she have a business? Does she have an LLC where she offers these services to the company through this LLC? Does she receive payment to that LLC, or is she getting paid cash? Is she just receiving the money personally? The fourth prong that you would have to, out of the 6, is that the independent contractor has to hold 1 or more bank accounts in the name of the business entity for purposes of paying business expenses or other expenses related to the services. So, does Alexa have a business? And if she does, does she have a bank account in the name of that business that she uses for her business expenses? So one of the business expenses might be her equipment. It says that she uses her own. It says that she's getting paid by the number of the hours, by the number of the people. That she does. And the question is, well, whose equipment is she using? Is she using her own equipment, or is it equipment that the company has supplied? The the fifth prong, so out of the six, the fifth prong is that you have to perform the work. You have to perform work or be able to perform work for any entity in addition to the employer, or in this case, the company. So is Alexa, in this case, able to work for other businesses? Does she provide these services for competitors or other businesses, or is she only allowed to work for the company? So that's an inquiry that'll definitely be made. And lastly, the last of these initial six prongs is, does she receive compensation for her work or services on a competitive bid basis or completion of a task or a set of tasks as defined by a contractual agreement? So if there's an inquiry, then an investigation could ensue, and a workers' comp investigator could come out and say, well, does Alexa meet 4 of these 6? And if she and ultimately it's Alexa, the company can say, yeah, she does, but Alexa's the one, the purported independent contractor is going to be the one who has to make and prove they have the burden, essentially. So workers' compensation is going to listen to the business, but they're ultimately going to want to talk to Alexa and find out from her how she works, what's the condition of her, what's the nature of the business that she's running and the services she provides. And let's say that Alexa doesn't meet any of these, right? And if that's the case, it's not, all hope is not lost. You can, the company could still successfully, or Alexa could still successfully be found to be a contractor and therefore not, eligible for workers' compensation. If she, and that's the second, and there's a second prong now where it's much looser, and the statute basically says that the Alexa could still be presumed to be an independent contractor based on full consideration of her individual situation, and if she satisfies any one of, and they give 7 other conditions under the statute, which is that she performs or agrees to perform specific services for a specific amount of money and controls the means of performing the work. So here she's agreed to get paid per person that she scans, and so it doesn't seem like she's supervised in the context of scanning people, so she may meet that prong. The second thing that they'll look at is to see if she incurs the principal expenses related to the work that she's doing. So again, that goes back to, does she sanitize her equipment, for example? Is it her equipment? Does she sanitize it? Does she pay for the cleaning materials? Does she pay for her? I'm sure she's probably wearing PPE. Does she pay for that sort of thing? And what kind of expenses does she incur with regard to these services that she's providing? And the third prong is that she has to be responsible. Well, is she responsible for satisfactory completion of the services? So in this case, we see that the equipment malfunctioned and there was a surge. Well, first of all, several employees were late. And so the question is there a repercussion for Alexa? If there is, and if there is, then that strengthens the case that, hey, she's an independent contractor. She's going to bear the she has a share basically, or there's a consequence for the quality of the work, even if it's just scanning people. And the fourth factor that they'll also look at is if she receives compensation on a per job basis, or on commission. And here, the getting paid on a per scan would seem to qualify for that. And just quickly, the last three is that, does she realize a profit or suffer a loss in connection with providing these services? Does she have continuing or recurring business liabilities or obligations? And lastly, I kind of touched on this, the success or the, well, I didn't actually, it's the success or the failure of her business depends on the relationship of business receipts to expenditures. So if you don't meet any of the first 4 of the 6 of the first test, then if you meet 1 or more of these last 7 that I just went through, then under a totality of the circumstances test, she could still be found to be a contractor and not a misclassified employee for purposes of workers' compensation.
Does it matter that in this case, Devante brought his dad and they're going through the same line? So you've got employees and non-employees or customers going through the same line. Anything for companies to be wary about there?
Sure. That raises an issue about worker safety, I would say, especially in today's climate. Is it a good idea to have employees and customers being scanned in the same line and standing there? And in this case, waiting for a long period of time. Is the line staggered in terms of social distancing or not? And it seems best practice to have a separate station for employees to be scanned versus customers. But that also brings up another question, which is, I'm sure everyone's heard that Governor DeSantis passed or executed an executive order, 2181, and that was issued on April 2nd, where the executive order bans COVID-19 vaccine passports. And part of that, though, is in Section 2, businesses are prohibited from requiring patrons or customers to provide any documentation certifying COVID vaccination. Here, in the scenario, all that's being done is temperatures are being taken, but you'd want to make sure that Alexa is not asking on behalf of the business any of the customers if they've been vaccinated as a prerequisite to enter the business. The executive order does, however, make clear under Section 5 that it doesn't restrict businesses from instituting COVID-19 screening protocols. So the fact that the business is screening customers and taking their temperatures is still fine going forward under that executive order.
Thanks. Rachel, let's talk about Billy, Carlos, and Devante, who were unable to clock in for 30 minutes and their supervisor wants to discipline them. And then Elena, Florence, and Grace, who refused to wait and just went to work. What do you see here?
Right. Well, obviously a number of different issues, Morey. With Billy, Carlos, and Devante, their being late in this case is a situation not of their making, but arguably one could say the same if they are taking public transportation and there's an accident that makes them late. What is different here is they were late because of a process instituted and implemented by the employer. And what we haven't touched on is whether that screening time is paid or unpaid. But for purposes of this hypothetical, that is not even the issue, because whether it's paid or unpaid time, the supervisor is saying you're late. You were supposed to be here. And well, here it was unpaid time because they were late clocking in for their shift. And there is law that supports that being unpaid time, having to go through a screening process. And in this case, it was the contractor and the swell of the malfunction of the equipment that made them late. The supervisor, while there may not be truly a legal issue in terms of discipline, there is certainly a human relations issue in terms of disciplining them for being late for a situation that, while it wasn't of their making, more importantly, it was of the employer's making. So that is an area where it would not make sense for the company to discipline them. There could be a note in the file. Maybe there's more information that we're not aware of, that after they did get through the screening line, they spent 10 minutes complaining about what happened, and then they were further late. But more interestingly, and we have an issue here with a different supervisor, is Elena, Florence, and Grace decided to bypass the screening line altogether. So they have violated company policy. They might not agree with the policy, but that is currently the policy, and there is nothing illegal about that policy. They're not objecting to the policy as a violation of any law, rule, or regulation. They're just saying that they don't like it. So they left the line, did not have temperature screening, and now HR wants to discipline them for failing to follow the policy. Their supervisor, Elena, Florence, and Grace, their supervisor maintains that because they had vaccination cards that they showed to the supervisor, they shouldn't be disciplined. So that raises a number of issues in terms of how the company is going to document the reason for disciplining Elena, Florence, and Grace, because it's very important to get that language right in order to prevent or defend against a claim that might come. It is fine to discipline them for violating the policy. That is, with the company taking the position, of course, that the policy was legal to require them to go through the screening, and it is. However, in terms of the vaccination cards, the supervisor needs to be advised by HR, okay, they showed you the vaccination cards, Ms. Supervisor, but you need to maintain that information in confidence. Even though your 3 employees voluntarily shared that health information with you, that is information that needs to be maintained in confidence, even though we, the employer, have not yet asked them to provide it. Now, just because Elena, Florence, and Grace showed the vaccination cards to the supervisor, that's not an excuse for their having violated the policy that they need to go through the temperature screening. So that the focus is on the violation of the policy, not on the excuse that they had. We don't want to get into their health status with respect to their refusal to get temperature screened. But then what happens, and we know all of this goes into the mix when trying to figure out how to discipline them and put language in, is Elena, Florence, and Grace decide to band together and circulate an email to all of the employees saying, you know what, temperature checks and masks are passé. We don't need them anymore because now everyone can get vaccinated. So why don't you join us in the lobby and not join us in the lobby, join us and lobby the company. You can come to the lobby too and stand socially distant. But let's come together and tell the company that we don't want to have this screening anymore because it's a waste of time. And it also made our colleagues late. But so what's important here is the company going to discipline Elena, Florence, and Grace for violating company policy? Is there going to be something in the documentation that's going to suggest or imply or actually state that they're being disciplined for coming together to complain about the policy of employee screening? Because that would be a violation of the National Labor Relations Act.
Right.
So many employers are like, well, wait a minute, we don't have a union in our workplace. Why do we have to worry about the National Labor Relations Act? And what most employers, may not, or what many employers may not realize is that there are still rights that all employees, all non-management employees have under the NLRA, including the right, and I'm quoting here, to act in concert with others regarding the terms of their employment. So even if we don't have a union at this internationally famous clothing manufacturer, Elena, Florence, and Grace have banded together, and even if it was just the 3 of them, it would be protected activity, but they have gone to the extra step of emailing all of the other employees and saying, we need to lobby our company to end this screening practice. So whether it's a good idea or a bad idea to end the screening, that is protected activity. We have non-management employees that are acting in concert, coming together to talk about the terms and conditions of their employment and how they might be changed, improved, but just a discussion about it. So it is critical that the employer not discipline the 3 of them for having that discussion and communication amongst themselves, and for mobilizing the other employees to continue having that discussion and to lobby the company.
Right. And then
yeah.
I couldn't agree with you more. And of course, I'm, the poster child for being on the lookout for group speak, as I refer to it, because it's always hidden in the background. And I think employers need to always focus on it and try to detect it as early as they can. And unfortunately worry about it from time to time. A question came up from the audience, which is, what about paying people? Like, we're talking about vaccination cards and people claiming to be vaccinated. Can the company ask to look at the vaccination card in order to pay people for having become vaccinated?
Yes, as long as, or if it's a yes and yes, but yes, but
right. Cautiously.
that vaccination card needs to be, if it's going to be retained, it needs to be retained in a confidential medical file. It should only be seen by a very limited group of people, or maybe perhaps only one person in human resources who is going to maintain the confidentiality of that information. So if an employer is going to incentivize its workforce to go get vaccinated by providing some amount of paid time off to go get the vaccine, then it is appropriate to require or ask for proof of vaccination before processing that paid time off. But what's critical at all times is confidentiality, and making sure that health information is kept in a confidential file. So I do want to remind everyone, if you do have questions, please, I don't think you can use the chat function, and don't raise your hand because we can't see you, even though you can see us, so we won't see that your virtual hand is raised. So please use the Q&A function on your screen to submit your questions. So further with vaccination cards, we also learned that Billy, he's one of our people that was 30 minutes late clocking in for his shift. Billy says, wait a minute, Grace had told me that she was not actually vaccinated and that the vaccination card she had was a forgery and that she actually opposes all vaccinations. So she just created this card, or went on the internet and bought a card to make it look like she was vaccinated. And she's going to use that card either to skip a line, have an excuse for skipping a line, or potentially to get paid time off if that's what the employer is providing. So Billy is now reporting this information. What can the employer do? Can the employer investigate? Can the employer discipline Grace for this? And the answer is yes, depending on what it is that you're disciplining her for. With that information, there could be a confidential investigation, limited in scope because it is dealing with Grace's health information, but the appropriate member of HR could meet with Grace and ask her to present the vaccination card, and almost similar to I-9 documents, determine if it reasonably appears to be genuine. And if the conclusion is, either if Grace admits that she forged it and that it's not real, or if the conclusion is that the document that she is presenting itself is not real, even if, Grace might actually be vaccinated, but she didn't bring in an actual legitimate vaccination card, Grace could be disciplined for presenting a forged document. But if Grace cannot be disciplined for opposing all vaccinations if that opposition is based in her sincerely held religious beliefs. So yes, Morey.
No, I'll stop you there because we just drew a question about mandatory vaccinations or mandatory masking, and whether or not companies can do one or the other or both. And when you said about a held religious belief, and I probably cut you off because you were probably going to say something about a health condition, but maybe you can respond to those two questions at one time.
Yes, and I'm just going to tell everyone I need to step off to the side so I can turn my lights back on by having motion, and then I'll come back on camera.
Right. Well, and I'll,
Okay.
I'll, oh, go ahead. You're back.
Yeah, no, I just needed to get my light back on.
Yeah.
That's all. So I'm going to pull up the question. So this had, can we ask employees that have, okay, wait. Sorry, Morey, which question were you on?
Well, either, can we have a mandatory vaccination policy, or can we require masks at the office?
Right. Well, you can have a mandatory vaccination policy as long as you're prepared for a few different things. One is if an employee has a sincerely held religious belief that prevents them from getting the vaccination, then that belief needs to be accommodated. If an employee has a disability and needs to be accommodated in that respect, then that's also a discussion that needs to be had, because we can't require people who, because of a disability, cannot have the vaccination. We can't require that they be vaccinated. But these are reasonable accommodations. So depending on the workplace, there may be something that would allow them to continue to work there while not receiving the vaccine. And it's important to have an individual interactive discussion with each individual who is presenting the religious or disability-based reason for not being vaccinated.
Right.
The question about whether to continue requiring masks, we have two separate issues going on. An employer's decision to either require vaccinations or to start collecting confidentially information about who's vaccinated and who's not, that is a separate conversation about other COVID-19 precautions. So while an employer is rolling out its vaccination policy, whatever that might be, that does not mean that all the rest of the employees are off the hook from following other COVID-19 precautions that the employer has not yet rescinded or ended. So there may still be a mask requirement in the workplace. There still might be a social distancing requirement in the workplace. There might still be screening before you can enter the building. Whether those safety precautions still have efficacy or not, we look to the CDC, we get the best information we can, but the employer might still have an overly cautious precaution or requirement in place, a screening requirement, safety requirement, and those need to be followed by the employees until the employer says they're rescinded, whether or not the employee has obtained the vaccination or not.
And, I'm glad, thank you. I'm glad people are asking questions. Another one is, what about someone who just doesn't believe in vaccinations? They're not disabled. They don't hold a religious objection to it. They just are not a fan of vaccinations.
Right, and right now that is not a protected class. So when it comes to mandatory vaccination policies, a company, an employer also needs to consider what are they going to do if someone does not have a religious objection or a disability that would prevent them from getting the vaccine if they just aren't going to get it.
Right.
And if you have a mandatory vaccination policy, does that mean that you are going to terminate their employment? If the answer is no, then you don't have a mandatory vaccination policy. So those are all of the different considerations to think about when implementing a vaccination policy.
Right. And one of the things I have spoken about with a client recently is, is the mandatory vaccination policy, like several of your other policies, going to help you, obtain and retain the best qualified workers for your specific jobs that you have available? And, you've got that mission that you've got to satisfy as well. Someone else asked a question, well, but confidentiality is, hard to achieve, because if we pay a bonus or we do something to reward people who are being vaccinated, then payroll will know who was vaccinated and other people will know who was vaccinated. And can we be exposed to a discrimination claim because some people are getting this money and other people are not getting this money?
So I think on the confidentiality perspective, if an employee does not want, well, let me put it this way. If an employer is going to offer an incentive for people to get vaccinated, then the employee, by virtue of claiming the incentive, they are consenting for those who need to know to be aware of their vaccination status.
Right.
And so that would be an important part of the policy, that an employee who is vaccinated might be required to present proof of vaccination to HR, which would be held in a confidential medical file. But that employee can also elect to forego the incentive. And that because they do not want that information shared, even with the limited expanded pool of people, which would be the payroll specialist or somebody else, a supervisor who they might have to say, I need the time off to go get the vaccine. Although there, I don't think an employee needs to tell their supervisor why they need the time off to that degree of specificity. If an employee tells their supervisor, I need to leave work early tomorrow at 3 to go to the doctor, they're not saying why they're going to the doctor or which type of doctor. So an employee could tell a supervisor, I'm leaving 2 hours early tomorrow for a medical appointment. And then they go get the vaccine. They present the vaccine card to HR. They don't claim the incentive, and everything is as confidential as the employee wants it to be. So we want the employees to maintain control over the confidentiality of that information to the extent that they want to keep it confidential. But if they are okay with some people knowing about it, then they can claim the incentive.
Right.
We had another question built in there too, Morey.
Oh, it was about exposure to potential discrimination if some people are being rewarded and other people aren't being rewarded.
Right. And there it's people bring claims all the time. Can they be defended? And if an employee, well, and the answer there is no, if the incentive policy is rolled out appropriately. That if someone has a sincerely held religious belief, so they're not going to get the vaccine, they're being accommodated in that belief, and they are electing still not to get the incentive. Similarly with a disability, we're not discriminating against people by not providing the incentive, but in the same way that we're not discriminating against them by terminating their employment because they're not able to be vaccinated because of a protected reason.
Right.
But there could be, not in those examples, but in terms of a mandatory vaccination policy that might not be so mandatory because there are very important people that you just have to retain within the ranks of the company, or somebody that you have to hire and for whatever reason they're not going to be vaccinated, but not for a protected reason. That's an area where a company could inadvertently step into a discriminatory situation where the people who are excused from vaccination, unofficially excused from vaccination, if they're all, white men, but people that are not getting hired or who lose their employment because they're not getting vaccinated and they don't have a religious or disability exemption, and they're not, if they fall into other protected classes, then there could be a discrimination claim there if they're being treated differently.
What about the company's decision to poll employees and whether they are or not getting vaccinated or have not yet been vaccinated?
Yeah, just the overarching concern there is confidentiality. Employers, because of COVID-19 and the need to keep the workplace safe and what we've learned about the virus, an employer can learn information about who is vaccinated or planning to be vaccinated for planning purposes in terms of returning the workforce to the facility if they have been working remotely for the time being, or if other changes to the workplace have been made to accommodate social distancing, but now we're looking at getting everyone back together, or looking at what other safety precautions can be discontinued, then it is legitimate to collect the information. But what's paramount, again, is confidentiality. Who's deploying the poll, who is getting the results, who maintains the results. And in some cases, the results, you may not know who it is that responded. So there's no way to connect the respondee. It's anecdotal information without verification or backup. But if we are collecting information that is connecting the vaccine to the individual respondent, particularly if we're saying, please share your vaccination card with HR, then as long as it's kept confidential and maintained in a password protected electronic file, and it's only accessible to a few people in human resources, then that is okay.
Changing subject slightly to weave in a question from one of the attendees. No problem with encouraging vaccination as opposed to mandating vaccination, right?
I'm sorry, say that again, Morey?
Instead of mandating a vaccination, an employer could simply encourage vaccination and not push the envelope nearly as far, right?
Right, but encouraging vaccination, while that is fine, and that might be what employers are doing with incentives or even without incentives, but just sharing the information provided by the CDC and others about the efficacy of the vaccine, we can encourage it. But any information that is shared with the employer still needs to be kept confidential,
right,
even if it's not a mandatory policy. And we know that a lot of our employees are sharing information themselves about their vaccination status. People have their stickers. We've got the Facebook, the overlay that can go on your profile picture that says I'm vaccinated. There's a lot of public sharing about that information, and employees are talking about it with each other. And if they want to do that, that's fine. But the employer in that role cannot share with others information about any individual employee's vaccination status, even if the employee himself or herself has posted it all over the world and everybody knows.
Right,
the employer still can't confirm or deny or say anything about it.
Right.
Now, there is a question about, are we going to differentiate and discriminate amongst vaccinated employees versus non-vaccinated employees? And can we require masks for non-vaccinated employees? And what that might do is get into a situation of disclosing by omission or differentiation who's vaccinated and who's not. But that's also a scenario that, for other reasons, that might not be a good idea from a human relations perspective. But anyone who's vaccinated can always choose to continue wearing a mask if that's what they want to do. No one's telling them they can't wear a mask. And many vaccinated people might choose to continue doing that. Similarly, if an employer is going to have some type of badge or bracelet or some other means of indication so that a vaccinated employee does not need to go through the screening process anymore, that's a way that would share a vaccination status about an employee. But if an employee doesn't want that information to be public, then that employee can still go through the screening process like everyone else and not disclose their vaccination status by electing to wear the badge that gets them kind of through the line without having to go through screening.
Let me go back quickly to the religious belief and the ability to potentially, or the need for an employer to potentially accommodate the religious belief to not be vaccinated. One of our attendees wants to know, how do you test the deeply held religious belief?
You don't.
Simply stated.
Right. I don't want to say unfortunately, because that's the whole point. Fortunately, we live in the United States where we treat religion in a certain way. And so that means that if an employee says that because of a sincerely held religious belief that, and they can identify, you can ask them a little bit like, well, what religion is it? And if they say, well, it's the religion of Morey, that actually won't fly.
I'm shocked, but
right,
moving
sorry,
on.
Morey,
Right.
but you are not a religion.
Right.
But for the most part, any employee, whether you know from them anecdotally talking about their church attendance or not church attendance, whether you believe them or not, if they say that their pastor has told them not to get the vaccine and they follow what their pastor says, then the employer needs to explore an accommodation.
Right. Right. Let's talk about Devontae's dad and coming to work that day and what issues, if any, arise from that. Abood, what if anything do you see there, including the dad's desire to sue the company and the company's desire to fire Devontae as a result of it?
Sure. There are a couple issues here. The fact that Devontae, that the company's thinking about that they want to fire Devontae. Again, you can terminate anyone for any reason, but if you want to avoid litigation or minimize your risk, you need to make sure it's a lawful reason. So in this case, can the company fire Devontae simply because his dad is wanting to sue the company? And the answer is yes. And we actually have case law in Florida from the 70s where a Publix employee, he was walking through a Publix supermarket with his 2-year-old daughter, and a soda bottle exploded and injured her eye. And so they were offered like $200 in settlement by the insurer, and they rejected that. And then he brought he went on to bring a lawsuit in the name of his daughter, and Publix, asked him to stop, and he didn't, and so they terminated him, and he filed a lawsuit. And the court said, and it was upheld on appeal, that he was an at-will employee, and terminating him, it was not a protected class. Suing your employer doesn't turn your at-will employment into an employment contract, so to speak. So yes, the company can terminate Devontae for this reason, but they would want to be really clear in their termination paperwork and all of the the paperwork that they're doing and leaving in the file, that to be very clear about the reasons for the termination, in order to be able to defend against what would likely, probably be a potential claim that he would bring. But then I guess the next question is that really, each company has to make a decision for itself. Would that be good for morale, for the PR? And those are other considerations aside from the fact that you can. Now, as for the father, whether or not Devontae supports him in what he's doing, he's going to have to keep in mind that, and I'm sure everyone knows that as of March 29th of this year, we have a new Florida statute, that 768.38, that gives protections from COVID-related claims to businesses, religious institutions, nonprofit institutions, educational institutions, and makes it more difficult for someone claiming that they've suffered COVID-related damages or injury or even a death for them to maintain a claim. And what this legislation specifically did, say that the father goes ahead and brings a lawsuit. Now he would have to, first, there are two requirements. He has to plead with specificity the nature of his claim. So you can't just say, well, I was at this store and I caught COVID and now I have injuries, and just have a very general pleading. You have to be specific as to the facts. how did you catch it? What have you experienced? Where did you get it? And those sorts of things. So that's a heightened pleading standard. And second, the father would have to find a physician, an actively licensed Florida physician, who would attest in an affidavit that the physician believes that the father, suffered or contracted COVID or suffered COVID-related damages or other injury due to this company's actions, right? And if the father meets those two, and the court examines that when such a lawsuit is filed, and if the father met those two, then there's still another prong, which is that business entities like this company are going to be protected from civil liability if they've made a good faith effort to substantially comply with the authoritative or with guidance or standards that were authoritative or controlling at the time. And I'm sure a question that pops up is, well, there are several standards that have come and gone, and sometimes there can be more than one standard, right? You have a CDC standard, you have Florida Department of Health standard that might differ, or you might even have local Department of Health standards. But if you follow any of those, if a business follows any of the controlling standards at the time and made a good faith effort to do so, then the lawsuit would still fail because that provides immunity from civil liability. And throughout all of this, it would be the father's burden to prove that the employer acted with gross negligence. And so what that means is that not just negligence, right? I slipped and fell up at a store. That's a tort, a suit based on negligence. But the standard that has to be proven is gross negligence, that a reasonable person knew that this would probably and likely harm someone, that their actions would, and to prove it by a clear and convincing standard. So not by a preponderance of the evidence, but you could say, but like a 75%, it's not quantified, but you could, just for purposes of demonstration, that's what a clear and convincing standard is. It's difficult. So in this case, in Florida, this company has more protection now. And lastly, let's say the father says, well, I don't want Devontae to lose his job, so I'm going to withdraw it. But then decides, 2 years later, he wants to bring the suit, and can he bring it? Actually, no, the statute now sets a 1-year statute of limitations. So he only has a year from, this exposure at the store where he argued he's exposed to bring this lawsuit. So those are some hurdles that he would have to get over.
So Abood, do you think then that companies that have customer facing or external facing roles need to perhaps differentiate between safety requirements for those people, that if you're interacting with customers or clients, then you still need to wear the face mask regardless of vaccination status, or you still need to go through temperature checks? What advice would you give for companies that have what I'll call external facing positions?
Sure. I don't think you can ever go wrong with continuing, especially in today's climate, with continuing to temperature check and to mask, keep good records of all that, because that's going to essentially insulate you from civil liability. And these suits are probably going to, I know Florida is, one of the states that we have some of the highest COVID-related litigation, and I don't think it's going to go away, although this statute might put a damper on it. But in the meantime, yeah, I don't think there's, unless, I guess a business would have to consider, is there really going to be such a harm to our operation or to some other really important business consideration that would outweigh having this this civil immunity from a COVID-related claim. So, that goes back to having the customers being in a different line, for example, than the employees. And like you said, Rachel, for them to maintain masking and temperature checks and whatnot, doesn't hurt generally to be cautious in this climate.
Right. Now I'm going to jump in and kind of layer on top of that a question that came in during your answer about mandatory vaccination policies. And if I understood the question correctly, does it depend on the type of business that the company runs, and is it easier or harder for certain types of companies to impose those types of policies? And as it relates to, and I'll answer it, as it relates to mandatory vaccination policies today, the EEOC has issued guidance that says essentially that a company can require a mandatory vaccination policy if that's what it wants to do. It would have to, of course, be attentive to disability type questions that employees raise and religious objections that employees raise, and they'd have to implement the policy in a non-discriminatory way generally. But as of today, companies can have mandatory vaccination policies, regardless of the industry that the company is in. Whether that changes or not, one doesn't know. And then what other questions, because we are very appreciative of your attendance today, but what other questions might you have in the limited time that we have, because we will do our best to answer them. And if you have them, please put them in the Q&A, and we'll try to get to them as quickly as we can.
Yeah, and while we're waiting for that, I think we want to clarify that Governor DeSantis's executive order, as written, does not apply to employees. It is for other people, customers coming into an establishment.
Well,
so sorry, Morey.
No, go ahead.
Okay. So we've had some great questions today. We're not seeing any additional questions. So hopefully that means we have answered or at least addressed the issues involved in whatever questions you might have brought with you into the seminar. As you're drafting your policy, whether it's mandatory vaccination or strongly encouraged or something else, just recognize that it's going to take time to get the policy the way you want it to be. This is not something to do quickly. And it can get frustrating as you review it and then identify other issues that might come up with the way it was written. So it needs to be rewritten to make sure that you don't step in a problem here or create another challenge there. So definitely take your time, get a small team of people to review the policy, talk about it with them, and get to a place where you're comfortable rolling it out and feel good about explaining the policy to your workforce and then enforcing the policy. But as I said, it's a tough time. And we know that people are stressed about vaccinations, stressed about COVID, stressed about working at home, might want to return to the workplace, might not want to return to the workplace. And we want to be attentive to all of those feelings, but definitely allow yourself to have the time to create the best policy that works for your workplace.
Right. Thank you all for attending. Obviously, if you have questions after the seminar, please reach out to any of us. We'd be more than happy to answer them. We do appreciate that you took the time today to spend it with us. Thanks.
Yes, thank you, everyone. Have a great day.
Take care.